Well, welcome back. Now, Public Protector Advocate Busisiwe Mkhwebane says that she's confident that she will be cleared of any wrongdoing. Now, she was responding to a recent report by an independent panel which found that there was prima facie evidence of misconduct and incompetence against her. The panel recommends that Parliament institute the process to have the Public Protector removed from office. Oupa Segalwe is spokesperson for the Public Protector Advocate Busisiwe Mkhwebane, and he joins us now to discuss this matter further. Mrs. Segalwe, thanks for your time. Welcome to Morning Live.
Good morning, Sakina, and thank you for the opportunity.
Now, the Public Protector's Office apparently says that the report pronounces on the alleged existence of this prima facie evidence against the Public Protector, but no finding of wrongdoing. So how exactly does the Office of the Public Protector interpret the report?
Well, the report should be interpreted just as we articulated in the statement we issued yesterday, that it amounts to a pronouncement on the alleged existence of a prima facie evidence. In other words, it has established that the Public Protector may have a case to answer. So it is not a finding of wrongdoing in itself. And we have made example of what happens in criminal proceedings. For instance, when the NPA receives a case docket from the police, they assess it to establish if it would amount to a winnable case, and at that point they enroll it for trial. And that does not mean the accused in that case will be found guilty. They may very well be acquitted at the end of the process. So that's how we interpret the report.
So, firstly, if you can confirm, did the Public Protector make those legal objections and request that the panel's work be discontinued or at least temporarily suspended, and on what basis?
Well, yes, it is true. Right at the beginning of this process, the Public Protector approached the Office of the Speaker to bring to her attention that there were problems with the rules upon which Parliament is relying on when it embarks on this process. And there was no agreement at that point, and the Public Protector then went to court on two fronts. Part A of that application to the High Court was to secure an interim interdict pending Part B, which would be the review of the rules to ensure that they pass muster with the Constitution. But as you know, the Public Protector was not successful in the High Court when it comes to the issue of obtaining an interim interdict. And that matter is currently before the Constitutional Court on appeal. We do not have a date yet as to when the case will be heard. But with regard to the review of the rules themselves, that matter is before the Western Cape High Court, and we expect it to be heard in June this year.
Now, Mr. Segalwe, the Public Protector says, and you reiterated that a short while ago, that you don't believe that there will be any findings of wrongdoing against her. But based on the evidence that was placed before it, the review panel actually says that there are grounds for Mkhwebane to answer to a case of incompetence at least. How do you respond to that?
Yes, that's exactly what we mean when we say the panel has merely established that the Public Protector may have a case to answer. But should matters get to that point, in other words, should there be an inquiry in the future, she will get a fair opportunity to state her side of the story, and she will be able to prove that actually there is no case against her.
So let's speak to that, allegation of incompetence against the Public Protector, because the panel used evidence, including recordings and court cases where the Public Protector has been found wanting in terms of the application of the law. So how does the Public Protector or your office respond to this? Because information is collected by your teams. So how can one then, some people would ask, defend some of the legalities, the legal problems and adverse findings by courts on several occasions, not just one, including the fact that the court said that she has lied on occasion? How do you defend all of that?
Well, first and foremost, people need to understand that the Public Protector can err. when conducting an investigation, just like the courts can err when hearing a case and when writing judgments. That is why in our legal framework in the country, there is this provision that once you are unhappy with the outcome of a public protector investigation, you are welcome to take it on review. That alone presupposes that there is an acceptance that the public protector is prone to err now and again, and it gives those who may have qualms with her findings an opportunity to get recourse through another forum. The same is applicable to the courts. If you are unhappy with a judgment, you go to a superior court for a review or for an appeal. And that is part of our legal framework. So it is nothing untoward. It's nothing out of the ordinary. It appears sometimes that people expect the public protector to walk on water, which are standards that are not even expected of judges.
Perhaps not to walk on water, but at the very least, one would want to have confidence in the office of the public protector. This is one of the most important Chapter 9 institutions that we have in this country to safeguard our democracy. So speaking to the accusations, the issue of perjury, and this is more than an accusation because there is a court case in this regard. So that particular case, can you give us an update on that and the other one that you refer to as well that is now going to the Constitutional Court?
Well, with respect to the case of perjury, the public protector did appear before the magistrates court in Pretoria. I think it was on the 21st of January, and that case was postponed to the 25th of March. But at that point, our counsel did make the court aware that during this period, the public protector will be making representations to the National Director of Public Prosecutions with a view to have the case struck off because she got hold of the docket of the case on the day of her appearance after weeks of trying to obtain it. And upon looking into it, we were convinced that there is no case to answer there. So that is where the process is. But apart from that issue of making representations to the National Director of Public Prosecutions, both parties in the case are taking care of all the pre-trial matters. And with regard to the one I referred to, which will be heard in the Constitutional Court, that is an appeal of the decision of the Western Cape High Court in our failed attempt to secure an interdict. And we are merely waiting for the Chief Justice to give us directions in terms of what will happen, when should papers be filed, and when will the case be heard to put this matter to rest.
And perhaps just coming back to the question of confidence in the office of the public protector, how do you restore that if the public protector is continually embroiled in court cases post the reports that she puts out in the public?
I think what the public first and foremost needs to understand is that there's nothing wrong with the public protector's review, reports being taken on review. You will recall that on 31st March 2016, the Constitutional Court handed down a judgment where it was said that the findings and remedial action of the public protector are binding unless set aside by the court of law. Now, that proviso, unless set aside by the court of law, invited this litigation. Before that case, we never had an influx of application for a review of our findings. So it should be seen in that context. And it's very unfair of people to look at what happens in the court and use that as a yardstick to determine whether or not the public protector is succeeding in implementing its mandate. What you need to look at is what is the public protector established for. This institution is established to investigate alleged improper conduct in state affairs, report on that conduct, and take appropriate remedial action. And we do that very successfully if you look at our annual reports. our core function is not to go to court and win cases. That is something else. Our core function is to investigate, and we do that very well if you look at our annual report, as I've said.
And, again, I think the emphasis there on the point that you also touch on, that the public's confidence does, in fact, wane, because perceptions are very powerful in terms of this continued, toing and froing and the public protector being in court. But what is the next step, Mr. Segalwe, with regard to the public protector and Parliament on the specific matter of the parliamentary process to actually remove the public protector from office?
Well, this is entirely a parliamentary process. So the public protector will take a cue from Parliament. But it looks like when the matter like this goes to Parliament, it enters a political arena. And this is something we tried to avoid all along through all of these engagements with the Office of the Speaker. And when they failed, we went to court. But now that it has entered that space, it can go either way. But the public protector will take a cue from Parliament and cooperate.
Mrs. Segalwe, we'll leave it there. Thank you so much for your time. Oupa Segalwe, spokesperson for the Public Protector, responding to some of the findings of the report that was commissioned by Parliament in order to assist Parliament to assess the advocate Busisiwe Mkhwebane, that's the Public Protector's conduct. And we will keep our eye on this one, as we have been all week. And your views also welcome at Morning Live SABC. But right now, let's take a quick break.